Hello. Hello, Navtika. Good evening.
Evening, sir.
Good evening. So we'll be starting at 7 o'clock. People are joining.
Sure, sir. No problem.
Puja Lakshmi, Rajkumar. I hope I'm audible. You can check your mind.
Yes, sir.
Okay. Okay.
I hope I'm audible, sir. A very warm good evening to one and all. I hope I'm audible.
Yes, yes.
Yes.
Each and every one of you on the speakers. We can shape
Puja,
national level fake.
you were you missed your voice. Please start. You missed your voice. You can start again.
Uh, I'm starting again. I hope it's okay with everyone. Am I audible, sir? Okay.
Yes.
I invite each and every one of you to embark on this transformative journey of professional growth, collaboration, and innovation. Let's embrace the challenges and opportunities of 21st century guided by the expertise of the speaker. Together, we can shape the future of legal education. And well, once again, I welcome everyone to the first ever 1 month national level faculty development program on teaching law in 21st century, a collaborative effort between Law Teachers India and Gujarat Maritime University, Gandhinagar. This program is a testament to our shared commitment to advance legal education and prepare educators for the challenges and opportunities of the 21st century. Today with us, we have our faculty coordinator, Mr. Rajkumar Gupta, who is an assistant professor of law at Faculty of Law of Maharaja Saijaro University, Baroda. He has pursued management from Rajiv Gandhi Institute of Technology, Mumbai, and sir has pursued LLM from CNLC Ranchi with specialization in corporate law. Sir has a rich experience of working with corporates like Roman Group, Panasonic, and many other companies. Over to you, sir.
Thank you. A very warm greeting to one and all present here for this FDP. So today is the 10th session of FDP, and our topic of discussion is going to be based on IPC. The Indian Penal Code is a comprehensive criminal code and that serves as the primary legislation governing criminal offences under rule. The IPC has undergone several amendments and continues to be the crucial legal framework for the Indian criminal justice system. The Indian Penal Code is a criminal code that outlines and defines various criminal offenses in India. Hence, it is a very important criminal legislation in India, which is often read with CRPC and Indian Evidence Act, and generally we call it as a major act. This subject is very important, and the law students also learning this subject with high level of curiosity. This is a little bit about the subject, and our today's guest has carried an immense knowledge and wisdom about the same. It is my privilege to introduce today's eminent resource person, Dr. Navtika Singh Nautiyal. Dr. Navtika Singh Nautiyal, presently working as an assistant professor in School of Law, Forensic Science and Policy Studies at National Forensic Sciences University, Gandhinagar, Gujarat. She has a rich experience of 9 years in teaching and research. She has completed her philosophy of doctorate in inter-country adoption law from Uttaranchal University, Dehradun, and LLM from the Indian Law Institute, New Delhi. Dr. Nautiyal has edited a book on e-waste management challenges and opportunity, which is published by Thomson Reuters Publishing House. She has published more than 29 articles and research papers, along with 60 research papers presented in both national and international events. She has delivered many keynote addresses on contemporary issues of law, management, research, personality development, and professional skills. She has delivered several motivational talks and webinars on a different topic. She has also adjudged several national and international competitions, and currently she is serving herself as a member of 21 prestigious editorial board members and reviewer in different national and international journals. She has also founded a virtual school on personality development and a professional skill for grooming future professionals. Dr. Nautiyal has a full scholarship to present her work in 10th Worldwide Conference of Global Alliance for Justice Education held in Indonesia. Dr. Nautiyal has also invited as a
I believe our sir has Gupta sir has some issues. Ma'am, you may start.
in
Uh, Pooja, you're not audible. However, if Kalpesh sir
am I
allows
audible?
me, may I start this?
Yes, we welcome you, ma'am, on this faculty development program. I request you to begin the session.
Thank you so much, Mr. Gupta. Thank you so much, Pooja, for this wonderful beginning. And my heartiest congratulations to Kalpesh sir and his complete team because it's not easy to organize an event because we may be seeing only this screen, but the behind task, it's not easy. So thank you so much and many congratulations. This subject which sir has given me, it's a task itself. Okay, because teaching IPC, I don't think so. We have yet developed a formula or a state, compartmentalized, kind of, strategy that, okay, this is the best strategy to teach IPC. Because 511 sections looks very, less, that okay, just 511 sections, in 6 months, but those 500 sections are not mere sections. They are philosophies. There are theories. There are jurisprudence behind it. So, friends, this is just an attempt to talk about the strategies to teach IPC. Uh, if you have better this thing, please share, because I am no expert. Let me just make it very clear, because every teacher has some unique USPs. So I'm just here to tell my USPs, that how I have I can deliver, or I used to deliver this subject, and I'm delivering. But every topic for me in IPC is different. Every chapter in category of offenses is completely different. I have to teach one concept with different strategy, and the other section in different strategy. So we are gonna to discuss about those strategies today, how to deal with different challenges, like how to complete the syllabus, uh, how to memorize sections, how to make students involved in the subject. So these are few of the things which we are going to talk. When I'm saying we means you and me both, because we all are faculties present on this platform. So bear with me for next 45 minutes, and then we'll open this platform for discussion. So I'm sharing my screen. I made a PPT. So for a better understanding, is it visible, Kalpesh sir?
Yeah, it should come up. Yeah.
Yeah, thank you. So friends, this is the scheme of my presentation, how I have divided the complete this task of teaching or strategies of IPC. First, we'll be talking about why to teach the subject, because the fundamental question sometimes comes is like, uh, let's divide the complete IPC evidence CRPC into two subjects, criminal law 1, criminal law 2, and let's teach them together, like teach three of the subjects together. So that is also one of the strategies, my friend. I'm not saying that this strategy is wrong, but let's understand that why to teach criminal law, because it's not only these subjects. There are sister concerned laws which we have to talk, and we'll talk about them also. So the first one is that. The second one is the teaching scheme of IPC, because it has 511 sections with so many chapters in it. So how to teach them? Because usually we got 5 modules or units in which the everything comes up in one platter, and how to teach, from where to begin. That is the first question, because in some universities they start with what is crime and historical development. In some of the university they talk about first the jurisprudence of criminal justice system. Somewhere I have seen that people start taken away elements of crime, memory and atmosphere. So what should be the teaching scheme of IPC? We have to, see in the second one. Third one is process of teaching IPC. I have had experience of, comparing more than 20 university syllabus, and majorly I had just jot down that this is the majorly acceptable process and flow of teaching IPC. So that in, this section will be talking about the process of this particular subject. And the last one is the teaching reflection. My friends, I'm taking this liberty to call all of you my friends, because there may be people who are, senior to me in this profession. Please pardon me for that. But teaching reflection is so important. Whenever we come from our class, we know that how much we have delivered today. There are some wonderful days, and there are so wonderful lessons, but there are classes, there are some topics in which ourselves we ourselves got so confused that how to teach the subject. I have seen some, faculty members, they have yet not able to differentiate between culpable homicide and murder. So whenever they hear the senior professors and they said that, oh, we have to teach, with this strategy. So I'm really sorry, friends. We are into that subject, which is people subject. People subject means there is a subject who can go to jail or who can be, who is in jail. And if we'll not be teaching this subject, to our future advocates properly, they, what they say is, uh, I don't know, this had not been taught in the law school. Law school teach only theories. What happened in court is completely practical. So it's not like this. I'm really sorry if your students with respect to criminal law says like this, that in court something different has happened, and in theory there is difference because we have just taught them sections. We have not taught them the philosophy of those sections. You must be wondering, ma'am, what do you mean by philosophy of those subjects? My friend, each and every, section, there is a philosophy behind, those 511 sections. So we'll be talking about those, reflections in the last this thing. So this is how we are going to discuss our this next 40 minutes, not 45 now. So the first one is analysis of teaching IPC. Uh, it may be possible that you have just done your master's in any of the specialization, and because you have studied IPC in your law school, so you got this subject to teach in your law school that okay, you have to teach, IPC in this semester. You must be wondering that from where I supposed to start. So that beginning, my friends, is first you have to please understand these objectives for teaching IPC. If these objectives are clear with you, then you will be able to, teach this subject, or you will aware your students about criminal law. So IPC is not Indian Penal Code. It's the first reflection of criminal law. So first of all, you have to learn that you have to aware your students about criminal law. About criminal law means, there are sister concern laws like criminology, penology, like criminal justice administration, evidence CRPC. Yes, it is there. But there are more subjects like international criminal law. So you have to make them aware that this is just a beginning of one of the branch of law. It is the most important branch of law. So you first have to, give that beginning that, okay, first you have to aware them. Second is you have to aware your students that what is a substantive, principle of criminal law, what is the, procedural principle of criminal law, what substantive laws give and what procedural laws give. So what happened is if we are not teaching IPC as law of crimes, and we are just teaching criminal law one, because there are law schools which they also do, there will be amalgamation of substantive and procedural law. So if your university follows this principle that you have to make a balance between substantive and procedural both, so this substantive principle is very important. The next one is there are challenges, there are nuances of crime, criminal law, and criminology. There are three sisters who go together, that this is crime, this is criminal law, and this is criminology. Then comes victimology and penology also. But at least criminology, basic knowledge, you should have. If you have not done, masters in criminal law, if your specialization is something else, and your university has not taught you criminology, penology, and victimology, because it's a one of the honor subject, and every university does not teach this, my friend. For you, teaching IPC is difficult. So you have to first learn about criminology, penology, and victimology, because every other section you have to relate to it. The next one is to make students interpret the principles of criminal law. It may be possible that you are discussing, 498A in your class, and Supreme Court has given a judgment where they have changed the scenario of 498A. Then what you'll do? You have to, uh, teach them how to understand the section, how to interpret the section. If you are developing that interpretation technique to them, it may be possible they're studying interpretation, but interpretation of criminal law is very important. If they are not understanding how they have to interpret the criminal law, I'm really sorry, we are failing as a teacher of criminal law. The next one is to make understand, to make students accomplish to apply criminal law. Here, which comes where a student says that my law school taught me, theories of criminal law. If we are failing to tell them that how to apply criminal law, it is very important to tell them that how the application of criminal law works. So, friends, if you can develop this, objective to them, then that gap between the theory and the application will be done away. The next one is to strengthen the understanding of students towards criminal law and criminal justice system. So, they should have a critical view, they should have a critical opinion to understand that, oh, okay, if this particular section, this particular word, let me give you one example here. In section 304, the dowry death, there is a word called soon before her death. Okay, so if in whole IPC, nowhere it is defined that what does soon means. Okay, and I don't think so. We 100 people also can define what could be soon. It depends on the fact, factual circumstances. It's a circumstantial situation. So if you are developing or you are strengthening that understanding of students, that soon could be one day in one case and soon could be 1 month in another case. We have to draw that line. It's not a thin line, 1 day and 1 month. It's, there are 29 days gap, but it may be possible that the dowry demand, the pressing of dowry demand, or the impact of dowry demand was not immediate. Another example is in this is imminent danger. What do you mean by imminent danger? For a child, an imminent danger and for an adult, imminent danger is different. So you have to strengthen that kind of understanding to your students. Then whenever they are, just reading a section, they shall not read plain meaning or the interpretation clause of that particular, section. They shall understand the philosophy, and this is the philosophy behind the words. I just given you two words. The one of the beautiful example is good faith. Section defines good faith, but the meaning of good faith is different in every case. So that kind of strength we have to develop in our students, that they will be they will be able to read the section with the facts and then understand the jurisprudence of that particular case. So this is the objectivity for teaching IPC. If you are able to understand all of this, friends, you are welcome to the gang. But if you are not, please let's work on it, because it's very important subject. It's not like any other subject. I'm not saying that other subjects are also not important. Every subject in law school is important, but this subject has little more importance, because deal with people directly. And we have seen that because of the mistakes of advocate, uh, there are issues, there are problems. So we have to understand this. So this is the objectivity of teaching IPC. Your questions are more than welcome. Please write in the chat box, and I will take them after my presentation. Then teaching strategy. Then comes, okay, ma'am, we have understand that why to teach IPC. Okay, basic understanding of thoughts also students have when I'm teaching IPC. I also love the subject. I have developed the understanding. Now, how to teach it? The question comes, and so many, good friends of mine, they asked me that, like, from where to begin? 511 section with the syllabus you have given me, but from where I have to start? The question comes, and friends, I start my class of IPC with the maxim, and you all must be knowing actus facitrium, mensitria, where I am just telling that why crime is important, what are the elements of crime, and when I just let them know what is crime, not the background history of crime or criminal law, then I go to the criminal law and how IPC has come, and what was the historical development. So we are coming to it. So majorly this is the scheme of IPC. All of you must be knowing it has offenses against human body, it has general offenses, it has offenses against property, and it has offenses related to marriage and reputation. So this is the scheme of division which all of us have it. Okay. So this is the first unit which has started with the introduction of criminal law. So how to introduce criminal law? Some of us does like we go give them a definition and tell them, okay, now interpret the definition and work on it. That is the first methodology. The second one is we just ask them, okay, you write a definition of criminal law and then let's start it. That is also right. So you see, no strategy is wrong. The a good teacher can make your students think. So first of all, before they will think or they will give you answers, give them a picture. Give them a picture that what are we are going to study. If you are able to give that good picture of criminal law, that why this criminal law is important for you, then they will all be able to understand the purpose and scope of criminal law. Because friends, the scope is unlimited. We all know that. What is the purpose of this subject? Why to teach criminal law? If you remember, earlier, what used to happen is there was no distinction. There was a civil wrong, there was a criminal wrong. Okay, so wrong is wrong. Now the civil wrong has to go to torts, and the criminal wrong becomes the criminal law. So the scope of this is that it is one of the branch of law where you are understanding the psychology, the sociology, the economy behind an act. I'm not saying that act is wrongful act or rightful because we have exceptions also. But why, how, when, by whom, by which kind of methodology the person has used, that is the scope of criminal law. It's not only a person has done an act and you are just punishing that person under XYZ section. It's not criminal law. Criminal law is who has done. That means the person. So you have to understand that who has done. Who means a person. Person has done. What was the situational aspect? What was the circumstances? What was the philosophy behind it? What was the force? Is it a sudden and great provocation? Everything about the person and the situation. The second is what he has done. That means an act. Act means the wrong. Wrong means whether he has stabbed somebody, whether he has stealed a food, so whether he has break a promise, he has promised you to go to a party, he just broke that particular promise, he has not come. So what particular act he has done? So whether that act or omission is wrongful or not, that you have to see. The third one is how he has done. So that how is methodology. So it's not easy that act, you just understand the act and you are punishing the person. No, you have to understand how he has done. How means how much? One stabbing, two stabbing, multiple stabbing. What? What was the weapon? He has done or somebody was forcing him, whether he was blackmailed by somebody. So you have to understand that. Then the result. Result means what is the outcome of that particular act. So from the person to the results, you have to understand the scope. This is the scope of criminal law. So it's not only that a theft has happened and you are giving punishment of 2 years to a person. No, who has done, against whom he has done, how he has done, what he has steal, after stealing, what he has done, for that particular, act, you have to understand. Okay, so that is the scope of criminal law. The nature and concept of crime, the act, then you have to understand that act, whether that act is wrong, illegal act, an offense, or it may be possible an executioner, who we call jallad also, he is just executing a capital punishment. So whether this act is crime, no, not at all. He is just performing his duty. A soldier is protecting a country, whether he is doing. So you have to understand the nature and concept of a crime. Then comes two beautiful words, actus reus and mens rea. We have, the complete criminal liability, which is important, is lies because of two words. So that's why I said that I start my lecture with that maxim, that actus non facit reum, nisi mensit rea, and in which an act also and intention also. I'm not saying a guilty act or a guilty intention. I'm just saying act and intention. We used to, explain to our uh, students. That is the first unit. Uh, Friends, first unit is very important. Uh, People say that, ma'am, first unit is not important because, we just have to make a base and let's go ahead because 511 sections are waiting for us. Friends, if they are able to understand the philosophy, the scope, the purpose, nature, concept, actus reus and mens rea, your half job is done to make them understand about the future act which are coming. So these are some of the this thing in first unit which we have to understand. We have done with substantive and procedural, concept of crime, why criminal law is relevant. You have to tell, this is a takeaway out of unit 1. You have to tell them why criminal law is relevant. Then it comes as historical background of criminal jurisprudence. Friends, there are two historical development of criminal jurisprudence. First is international, from how the criminal jurisprudence has evolved. If there are faculties of criminal law, they may be able to relate to this particular concept, where we have seen that from West it has come to India. Earlier there are theories of punishment where even a stone, where even a animal used to get punishment under criminal law. So that kind of criminal jurisprudence, and then Indian criminal jurisprudence. It's not IPC, which is Indian criminal jurisprudence only. It has it has started from the Hindu period, or ancient period, I must say that, from where it was a king made law, and then it has started to Muslim law, and then Britishers talked about criminal jurisprudence, and then they have drafted Indian penal code. Even the drafting of criminal IPC is important, because they have done a thorough study that, okay, we have to make these section, what could be the philosophy behind. So that is also important. You have to teach your students to that also. Then comes as jurisdiction. Friends, in IPC, this is the first thing from bare provision, which you have to teach about the intra and extraterritorial jurisdiction. We just teach them, okay, what is inside India along with the flag and everything. It is intra-territorial jurisdiction, which is outside. It's extraterritorial jurisdiction. Then we teach them basic provisions and then go. No, there are leading case laws like M.H. George case. You have to teach at least take complete 2 classes about jurisdiction and explain them that what is inter and extraterritorial jurisdiction, so that they will be able to explain to their client when they are coming tomorrow. They will be not be wondering what will be the extraterritorial jurisdiction. Then comes as interpretation clause, and I will take this when I'll be talking about the bare provision, that why interpretation clause is most important. Then comes section 34 and 149. Yes, from this everything started with unlawful assembly, and this comes as the first thing which you have to teach to your students, that friends, from this the criminal act started. Even if you are part of a group, they are planning something wrong and you're just part of the group, you can be one of the culprits. So, this started the actual criminal law from interpretation clause also. Then comes as that when we are teaching criminal law, shall we connect it with sister concern laws? Yes. Criminal law alone you cannot teach. You have to connect it with Arms Act. You have to connect it with NDPS. You have to connect it with you have to connect it with the psychology. You have to connect it with so many such a concern laws. So it's not single, law. It's an umbrella, and the task is you have to finish this in 4 months, not even 6 months. We doesn't get 6 months for a semester. So that is, the task, real task for us being teachers. Then comes a second unit, which is not a unit which you just can ignore and go. That is the general defenses. My friends, each general defense, I remember when, if you have read the arguments of No One Can, Jessica Lal murder case, where Mr. Malani has given argument about intoxication. You know how well read he has done. So let's understand that philosophy of general defense. If we are able to connect them to that kind of general defense, our job is done. So teach them general defense if they wants to be a good defense lawyer. If they want to be a good public, prosecutor, teach them general defenses so that they can defend the defense. So this is people say 299 and 300 is the heartbeat of IPC. I say general defenses is the soul of IPC. If you have the grip over general defenses, halfway done. If you have teach till 100 and six, that is right to private defense of body, half job done, my friend. So teach general defenses, like they have to understand and they have to save their client tomorrow only. So take one particular, this thing, for example, Donley Incapit. Take that particular this thing connected with juvenile, Justice Act, connected with POXO, and then teach them that this will come into picture. So if you are teaching them like this, if you are thinking that okay, I'll teach, Dolly Incapit separately, and then I will teach them juvenile Justice Act, I'm really sorry, we are failing as a teacher. So when you are teaching them this, teach that also. When you are teaching them intoxication, teach them NDPS, take relevant section there only. When you are teaching them self-defense, teach them about the Arms Act and how to take license also. When this is the way we have to connect, my friend. So that is the strategy of general defenses. The third unit comes with this. Okay, let's quickly take. I know all of you knows general defenses, but I want to just here uh, take a pause and tell you that these are not concept. These are defenses. So teach them as defenses only. Don't teach them as okay, there is a necessity, and if it is so necessary, then we can do this. No, teach them that if necessity is there, what they do mean by necessity, and these are the circumstances of necessity. So this is my take about the unit 2. Then comes as most ignorable and quickly finishing unit, that is offenses against state, public tranquility, or administration of justice. Friends, if you read FIR, there are so many sections where abatement becomes a charge. There are so many sections where criminal conspiracy charge is there. There are so many sections where sedition or conspiracy to waging war, plays a important role. There are so many, sections where rioting becomes, subcharge. So this is not ignorable one. What we do is, from general defenses, we go to offenses against body. Take at least 6 to 7 classes. Teach them about abatement. Teach them why abatement or when abatement can be punishable. Teach them when they can be liable of abatement. So teach them this. If you are not teaching them, you're thinking, okay, if I'll get time and then I'll be finishing it. No. Teach them this because it's not only a module. This is offenses against state. There are so many, offenses where punishment are so major, and we are not making concepts of people or concept of our students clear, and then they are not able to take care of it. So take at least 6 to 7 classes. I know we have a war to finish, but take at least 6 classes, which is my suggestions to each one of you. And then comes as unit 4, which is offenses against human body, and we think that this is everything of IPC. Yes, friends, this is everything of IPC because major cases and major offenses comes from this section only. And in this, the first one is culpable homicide and murder, the devil, 299 and 300. Teacher says that if you are a good criminal law teacher, then you should, make your students understand only culpable homicide and murder. Yes, it is not easy. I tell you, in one of my teaching assignment when I was teaching IPC, I took 1 month and 15 days to finish this chapter. And after that, I was wondering, I have to finish the whole syllabus. That was a challenge for me. And then I was like, what shall I do? Shall I leave some of the sections untouched, or shall I give my students notes and they'll just read themselves? That is the challenge which comes. So friends, it is important to teach culpable homicide and murder in depth. I'm not denying. Take minimum 5 to 6 or 6 to 7 classes about this, because it's not easy. It is not easy. At least the way these two sections being drafted. So give them a thorough reading. They are coming after reading, and then just teach them that okay, you have read this. Let's discuss this. So that is the strategy which, second or third time I used to have when I was teaching culpable homicide and murder, that I used to give them that, okay, today we are talking about exception 1. So you first read exception 1, understand about it, then we are going to discuss. I am not going to teach you. We are going to discuss. So this, it has become very easy if you ask them to, one by one, you don't give them, okay, read 5 exception and come. No, don't do this. Read first exception and come. That is the strategy which we have to have. Then dowry, death, and cruelty by husband and relative. It is where most of the cases nowadays lies. So teach this section properly. And when in the beginning I've given you example that soon before her death, here give them good case law. Friends, teaching dowry debt becomes easy when you are giving them good case law. So give them good case laws when you are discussing dowry debt. Next comes hurt and grievous hurt. A grievous hurt is defined properly in depth, but what about hurt? What about assault and battery, which they have understood in their thoughts classes? So teach them hurt and grievous hurt and the thin line between the two. Here, take a role or ask your faculty from forensic science to take 1 or 2 class about the grievous hurt, because it's not easy. Even in culpable homicide, murder, and grievous hurt, you can ask a faculty to take a class, from forensic science, and they can teach them that okay, even if there is a death, okay, but this could be death due to grievous hurt, and this can lie in section 304 Part 1 or Part 2. So, it's not always culpable homicide and murder. What about culpable homicide not amounting to murder? So, please ask your faculty. They will be telling, with their experience, that if it is, post-mortem report, how to read it. So here, your task would be easy to tell them. Then wrongful restraint and confinement comes into picture. uh, People still confused between the wrongful restraint and wrongful confinement done by public servant or done by administration. So teach them, in a way that they will be able to understand that what is wrongful restraint and wrongful confinement. If my DM is giving order of, route diversion, take a newspaper cutting and ask them whether it is a wrongful restraint. They will say that it is a restraint, but what is wrongful in it? Then tell them the meaning from general exception, where wrongful is given, that what could be a wrongful restraint and confinement, they'll understand. But whether this is wrongful or not, please make them understand. The next one is kidnapping and abduction. Yes, it is important, and tell them that what is kidnapping and abduction, and teach this particular concept with case laws. Why I'm saying kidnapping and abduction? Because there are case laws. For example, you taught them, okay, this is kidnapping, this is abduction, done. But what if they got a case where a father, who has got divorced from her wife, and now he has took the child without telling mother out of school whether this is kidnapping or not. Teach them with case laws, because those are the practical problems which they are going to face. What if, a teacher who has given a punishment to a student, and he has not informed the parents whether it can lie to kidnapping, because parents are not getting informed. The child is in the school after school hours. I have seen cases where there are cases. So please teach them by this. Then comes as criminal force and assault. When a force can be a criminal force, and differentiate it with assault. Because my friends, there is a confusion between a force, a criminal force, assault, battery, you know, uh, all of them. So give them proper instances. I'm not saying it may be possible that there are no cases, but there will be instances, illustration, where you can take illustrations from law of torts, and you can teach them that this is, in torts, and this is in law. Then comes as obscenity. Don't read the section of obscenity of IPC and just tell them this is obscenity. And don't even ignore this concept. Why not to ignore? Because in this, world of technology, obscenity becomes a major, this thing, where you may be possibly taking the screenshot of mine and creating a meme. So whether it will be wrong, what is obscene in it, I'm not saying. But what if you are creating, you are taking a person's picture, and you are just doing a Photoshop of that picture, and it is a content which is not right. So teach them obscenity properly. Then forgery, please, in the world of cut, copy, paste, or chat GPT, what can be forgery? Please teach them, so that they will have utmost knowledge of ethics. Bigamy, is not now, is so important, and now not in the syllabus. It is a old syllabus. Adultery, teach them adultery with examples, that okay, how and when can be. This has to be the approach that started from culpable homicide and murder, and take this. I have intentionally left one particular section out of it, that is, offenses against women. I'll take that topic at last, and please remind me to take that, because uh, we all can't teach offenses against women so easily. I'm going to take that chapter, at last. Then comes as offenses against property. So these are most of the offenses against property. There is one simple trick of teaching them. Teach through examples and stories. If you can take few clips out of YouTube or from case laws or web series, take those um, clips and teach them through act. Don't think that you'll just read the section and for example, this is the mouse. Take the mouse and put it somewhere else. That is a moving of property. Explain them that what could be a moving of property under theft. So, just do it. Then they will be able to understand. Otherwise, it's not easy. It's not easy to teach or differentiate between, extortion, theft, and robbery. If you're not teaching them, with examples, with practicals, uh, if you're not telling them what could be cheating with, proper demonstration, it won't be sufficing it. Then they'll not be understanding the difference between misappropriation of property and criminal breach of trust. Friends, we have to teach this with most practical sense, and it's very easy. In 10 classes, complete offenses against property would be done if you are teaching them with proper technique. Okay. Excuse me. Then the teaching, method comes as the most challenging one. That okay, some people say case method, and I don't want to name the universities, but they said that only case method is the good way of teaching a criminal. Some says no, illustration method is good. Give them illustration, teach them, they'll learn. Some say discussion method. Involve them, they'll discuss, they'll learn. Some say Socrative method. Teach them, they'll learn. Some say drafting method. Let them draft it. When they will be making a law, they'll be understanding the philosophy, they'll be understanding the plane of law, and they'll learn. Some say just review. Give them section, let them review, let them submit the report, done. Friends, they all are absolutely right, but you have to have all of them in your teaching methods. Because if you will take one, you will not be able to solve it, because every section, as just we discussed, every section of IPC is different. It's not even in sync. It's not even in hierarchy that okay, first you teach this, second you teach this, third you teach this. If you started with offenses against property, also fine. If you started with offenses against body, fine, because they two are separate branches, separate things. So if you think that you'll give lecture on everything, I'm really sorry. If you think that case met you'll give and they'll be able to understand, no. So everything, every method, these are some of the methodologies for teaching IPC. They all are absolutely correct. Case method, yes. Problem method, yes. Give them problem. That is another interesting which I just missed. Give them problem. They will understand the law and they will come back to you. Very good, interesting one. Role playing. How role playing is important because, for example, it is attempt to commit suicide. Just give them a role play that you want to, you are so depressed, you are so suppressed. For example, you are a 12th student, you have done your 100% and your result is so bad, and you are feeling, to commit suicide. What would be your feelings by that moment? It's a it's a kind of understanding. For example, a person who just joined a college and others are taking ragging and making a mockery or making a fun of that person. Take a role play and the person wants to commit suicide. Just you will be able to understand that what would be the psychology, what would be the impression of each of them in that role play. Multimedia, just I have told you that you can teach property law through, sorry, property law, the property offenses through multimedia. Another, very interesting tool. Please use it. Drafting documents, yes. Modeling. For example, when we are talking about some of these laws, for example, sedition, take a concept of modeling, that what other countries are following the model, and then just see, do a comparative analysis and teach them that what they are doing, how we are doing, or what are our what is missing in that section, that is there. What's out of class and online teaching, take them to jail, take them to court, take them to correctional facility. That kind of psychological understanding which they'll have, they'll understand the criminal jurisprudence. So take them. Then study groups, team activities, and tutoring. Yes, you please do it. Then persuasive method of teaching ethic. What is this? uh, Teach them that how much you need to teach them and how much they have to understand. Self study also, because 511 section, I'm really sorry, you'll not be able to finish. So tell them that okay, this much I'm gonna do, these sections which are pressing, I'm gonna to do it to you. These are friends, you have to just understand, and if you are facing any problem, come back to me. So this is next. This I was talking to you all. This is one of my favorite. I'm really sorry. This is so much colorful. Just see, there is the section of theft, and I have underlined the word dishonestly. Movable property out of the possession without the person's consent moves. The when you are teaching this section, break this section into the ingredients. For example, whoever. So whoever means a person who can be anyone. Okay. Intending, teach them what is intention here. Okay, if you're not teaching them intention here, it may be possible that your friend by mistake has taken something. He must not have an intention to do that. So intention is important. Take dishonestly. When you are connecting intention, tell them that the intention has to be dishonestly. Okay. Then movable property. Here, friends, if you're not connecting it to property law, I'm really sorry, it is incomplete. So tell them what is movable property, what is immovable property. Uh, then out of the possession, you have to tell them that what is out of the possession. So here you have to teach them possession also. You must be thinking that how much I have to teach in one section. But you have to, if you want to make, if you want to break between the theory and the practical, you have to tell them that what, this section means out of the possession does not mean that out of the household or out of the ownership. It is out of the possession of any person without the person's consent. So here consent connected to the contract law, and tell them that what is consent, how consent can be free consent, and when it is with consent and without consent. Then tell them what is moving. Moving to out of the possession does not mean that moving from one house to another house. It could be from one place to another place. Remember that illustration where from the person has took from table and put it behind the sofa. That is moving in one house, in one same room, but out of the possession moves that property in order or to such taking. Then the trick comes, what is in order to such taking. If in order to such taking is missing, it is not theft. That is the catch here. If we just read it, okay, in order to take it, he must have intention to take it. And then if he does not have an intention to take in order to such taking, then he just want to teach a lesson to his friend who is just a person who does not hold or handle his things carefully. He just want to teach a lesson. He has done everything. Okay, I am going to teach this man a lesson. I have this intention. He has took a property out of the possession, moved it from one place to another place, but he does not have an intention to take that property. So friends, if we have this understanding, IPC is the most lovable subject for you. Okay, so this is my take. I'm not going to take it, the complete section. Then teaching reflections. These are challenges. Yes, there are challenges. First is will not be able to complete all sections. Yes, you will not be. So accept these challenges, my friends, and there are few of the challenges which you can overcome. But if you think that you can become a Shaktiman and you can finish all the 500 sections of IPC, I am also going to come and take a lecture from you. The second one is reference of so many cases and sections. If you are giving them reference of cases and sections, then only the subject is, interesting for you. Otherwise, it can be as bored as any other. The next one is you have to connect IPC to any other laws. I have given you examples of, other laws. If you're not connecting IPC with other laws, IPC would be incomplete because you cannot teach a criminal law alone. You have to, and I'm saying have to. Then have to update with case laws and other laws. It may be possible you have missed today's newspaper and your student have just updated with the knowledge and he is coming to the class and you have not updated. So what you will be, there will be embarrassing situation. So friends, please update with relevant laws, case laws, other laws also. It may be possible that you are teaching them about a gun, and court said that in private defense, if you are snatching other person's gun and you are shooting that person, it could be taken, and you are saying no, it is not right. That means you have not had update of other laws. Take update of other laws too. I know I am asking little much, but this is not easy subject. Then you'll get confused about where to stop and where not to. As I got confused, I shared my experience that I teach, culpable homicide and murder in almost like 25 classes. That was my situation. So, friends, you should learn where to stop. How many case laws? Give them reading. Okay, 10 cases I have taught you in this, 20 you have to read. So give them these, this thing. So I have even mentioned that challenge of mine, the 299 in 3 seconds. Take around 15 classes. I'm not saying don't take, good amount of classes because it is heart and soul. Okay, but not more than. Okay, but this 299 and 300 taking 25 classes, I'm really sorry. Even I was, the thing. Then will be difficult to teach sexual offenses. Friends, our college or our students are, Generation Z. We say that they are much more advanced to us, but teaching them sexual offenses, teaching them rape offenses, rape clauses, teaching in that particular section, you have to first give them a gender sensitivity lecture, because you may be a female, you may be a male, you have to you know you have to give them that lecture. So it may be possible that you have to take one extra lecture, give them that sensitivity that, okay, from next class onwards, we are going to discuss some personal offenses, and we have to, because, to make them understand, because there are law colleges, the law schools, which what they do is they say that, okay, this is 376, you read it, done, finished. No, just tell them that, when it is, intercourse, what could be sex, what could be oral sex, teach them. I'm not, saying, but before teaching them, give them that, sensitivity, so that, you know, uh, uh, it will be easy for you to teach. So that I have, taken it as a challenge, and take it as a challenge. Do not leave it, because, it happens, you may be a, young in your profession, and you must be thinking that how to teach this particular, sexual offenses. Am I only to give them a plain reading and finish this? No. Give them a plain reading, explain them the complete section, tell them everything. But before that, make them aware that what you are going to discuss. Because we are in India, okay? So we have to respect other people too, and other gender too. So tell them that, okay, we are going to discuss, then it will be easy for you. The last thing for the day, I'm really sorry I've taken 5 more minutes, like 5 extra minutes. Fall in love with the subject. The day you'll say that I love criminal law, it will be easy for you to teach the subject. Read as much as you can. take the, go to the library, take the old books of criminal, jurisprudence, as much as you can. When I started my passion for criminal law, I have read almost, 12 to 13 books in one go, and I was like, this is my subject. So please read as much as you can. Read the good books, read the good cases, read the good arguments also. It's not only you are reading Supreme Court and High Court. Go to the, argument of district court and read that, at the time of trial, what kind of arguments are coming. Then, give examples. Like our, just narrate like a story. Involve your students in illustration. It's like you are just creating a picture in front of them, and that crime is just happening in front of their eyes. If you will be involved, like this, they will fall in love, in the particular subject. Let them debate also about the gender neutral laws, about the criminal conspiracy, about, sedition. If they'll debate, they will be, a good, drafter tomorrow, a good, advocate tomorrow. So let them debate. Remember, every section is, important and has importance. Don't leave any section. Just tell your student to read the section and, to, understand that, philosophy of that section, and then teach with different pedagogy. That is my final take to each one of you. If you are teaching, every other section with different pedagogy, which is the requirement of that particular concept, then IPC is your forte. With this, thank you so much. I know I have taken a little more time. Sorry for that. And thank you so much for your patience. Now I'm open to your question answer.
Thank you very much, ma'am. Participant, you can raise your hand. I'll be unmute you, or you can drop brief question, preferably, because it will take a lot of time to read little lengthy ones. By the time I can read, like there are questions. Let me start from latest one. So, what should be the approach while teaching criminal law to PG student? So, question is from Pratik.
Wonderful question, Pratik. When I done my, specialization of criminal law, I remember the lectures of BT Call sir, and he has the understanding and philosophical understanding of every concept. So, when you are teaching to UG, give them the case laws, okay? But when you are teaching to PG, give them philosophy, why this particular section or why this particular concept has come. Because in PG, we don't have IPC as it, we have criminal law. And criminal law means the philosophy, the jurisprudence. So please, you gather the philosophy of that particular, concept, and then teach the PG student.
Okay, there's a question from Rajaram Garud. Within one semester, it is not possible to cover all syllabus of IPC. So, what is your opinion regarding division of half portion for one semester and half for the next semester?
BCI gave us a good number of list of subjects which we have to teach in 3 years and 5 years. So if we'll start breaking, I know even I am of the opinion that IPC has to be into, same with CRPC, it has to be into, same with so many subjects, but, it's not in our hand. But if it is, we can discuss, in length, and we can give little more time to the most pressing, section. But if it is not, then the strategy that, okay, let's something students will do, some things we will do. But if it is in two, it's good. Yes, I agree. Sir.
So, I'm part of, let me give this example. This related to this question. I'm part of a member of academic the curriculum committee at one of the university at Surat. So, they have put up IPC like crime one and crime two, and then CRPC is there. Generally, crime one, like for example, it's IPC, and then other one is CRPC. This is a general like practice, but they have put up that the crime 1 and 2, and then CRPC is there. Again, it's for the convenience how they handle. Obviously, okay, let me go through some questions, the previous one. Participant, by the time you can raise your hand, I will unmute you.
I hope I was able to justify the topic which sir has given. And if you all have any question, please you can email me also. I'm writing my email ID in the chat box.
A lot of messages. Thank you messages are there, so I have to skip. Yes, participant. Yes, Nikta, I'm unmuting you. Yeah, Sibna, over to you.
Hello, good evening, ma'am.
Good evening.
Hi, ma'am. Thank you for the wonderful session. I
Thank
have
you,
one
Navtika.
one query, which I think
Please.
most of us would have, that while teaching any substantive law, it is very difficult for the students to remember the section number. They remember the gist, they remember the provision, but they get confused while remembering the section number. So, do you have any suggestions, uh, some sort of strategy which we could, imply, or which could help students in remembering the correct section number? Because the whole
Uh,
answer gets, the meaning changes.
Snigdha,
They write the
let me
provision
tell
correctly,
you.
but the number they fail to remember.
Absolutely. So they just have to remember the sections for passing the exam, because in court they have bare acts with them. So it's not like they're going to the court without any supporting, supplement. So just tell them that because it is a problem, because more than 5 lakh sections, articles they have to remember. So how much they can. So tell them the important one, if they are remembering through the concept. For example, if they are remembering grievous hurt under section this, then they'll remember. But if they'll remember section 323 talks about grievous hurt, it will be difficult for them. So, tell them that they can take the concept and then section. And just tell them that they need to remember hardly 15 sections out of the complete 511. Otherwise, in practice, where the real exam would be, they'll have bare act always. I remember I interacted with Ramjet Malani sir, and he said that even when I sleep, the bare act of IPC and the Constitution is there on my sleeping side. So that much love, he has. He's like, it may be possible that at night I used to remember anything, and I may be going through the bare act. So, they should carry bare act with them if they are having the habit of, the problem is, even we teachers are telling them, okay, if you can open your bare act in phone, laptop, or, it's okay. If they're carrying the hard copy of their bare act, they can easily, open it up, turn the pages. I know I'm talking little traditional here, but they can underline it, they can remember, they can see it anytime, and they'll connect with it. So that is the only approach which we can give them. Otherwise, this is a generation which is chat GPT generation. So they are not remembering anything now. So this is my take on this. Thank you for the lovely question.
Question chat box, and what are your views on open book exam?
See, we used to have a debate on this, but open book is okay. But if the level of your question paper is good, even they'll not get in any book. They have to just think and write. So if we will take, we'll take care of the pattern of our questions, quality of question paper. Then whether it is open book, whether it is traditional exam, not a problem. So we have to just see that, what kind of quality we are giving in our, questions. Whether they are thinking and writing or not, that is important. Sir,
Are we done with the question? Anyone like to ask? You can raise your hand. Yes, we are done with the questions. Yeah, so thank you very much, madam, for enlightening session. I have never taught IPC. This is not my cup of tea.
sir,
So
one
again,
person is just there. If we'll allow him, he has raised his hand.
yeah,
Chandrasekhar,
yeah,
please allow
yeah.
him. Yeah, then I know this is time for dinner.
Okay, Chandrasekhar, no. Dr. Chandrasekhar, I'm unmuting you. Over to you.
Hello, good
Yes,
evening,
sir. Over to
madam.
you.
Good evening, sir.
Madam, it is an excellent talk on or the topic you have covered or everything you have covered, madam. But when
Thank
we
you
are
so much, sir.
LLB students, starting with in-its outlines on criminal law. Now, how much the relevance is there nowadays? Nowadays, what happened? I saw that nobody is referring that book, and I think that is the base for I think.
So the problem is we are not given them the quality books. We are just saying, okay, refer this X book, refer this Y book. I'm not naming here. But if we are telling them, okay, for general principles, you have to refer, KNC
Yes.
Pillar. If we are
Yeah.
setting that base,
Yeah.
then KD Gore is easy for them. But if we are saying, okay, you can read from SN Mishra and you can go anywhere and any IPC book or the blogs from online is okay. I'm
Yeah.
sorry, we are just ending the whole war there. That is the
Yes.
problem.
Yes, madam. Yes, madam. Thank you.
Yes,
Thank
sir.
you.
Thank you, sir.
Thank you very much, sir.
Over to you, Kalpesh sir ji.
Yeah. Okay, thank you very much, madam. Rajkumar, over to you.
Am I audible?
Yes, yes.
Good evening, one and all. I'm feeling honored to in proposing a vote of thanks in this 10th session of Faculty Development Program organized by the Law Teachers India and Gujarat Maritime University, Gandhinagar. I hope you all have enriched your knowledge to the next level by attending this FDP. At first, I am extending my gratitude to Dr. Navtika Singh Nautiyal for such a wonderful lecture on IPC. Your lecture has covered all the nuances of the subject, madam, and you also dealt with many things right from the objectives of the teaching IPC, scheme of IPC, general defenses, offenses against state, public tranquility, administration of justice, offenses against human body and property. Madam also described the teaching methods like case study, role play, multimedia, modeling comparative study. Madam also shows us how to break the section and discuss every essential ingredient in a great length. She also advised to use the relevant case laws and connect IPC with the other acts as well. Madam also discusses the challenges to teach the subject. The interaction with the participant was really outstanding. Thank you so much, ma'am, for this lecture. It was so alive, informative, and encouraging. I also extend my sincere gratitude to Dr. Kalpesh Gupta sir and his team for their hard work and to organize this National FDP Edition 1 so successfully. I also extend my thanks to all the participants who joined the FDP program and make it successful. Thank you.
Thank you so much, dear, for this
Thank
wonderful
you. Thank you
insight.
very much,
And
ma'am.
I want to
Thank
thank
you.
Kalpesh
Thank you.
sir. Thank you
Thank you,
so much,
madam.
sir, for inviting
Thank
me.
you, Mr.
I
Okay,
hope
thank
I
you.
will be able, I am able to justify the topic. Thank you.
Thank you very much.